I'm Jeff Harrison. I'm here on behalf of Mr. Johnson. He's making his way up to the table as we speak.
All right, thank you very much. Mr. Johnson is now at the table. Mr. Sean Van Atwell also joins us today. He is the agent from the Michigan Department of Corrections who prepared today's pre-sentence investigation report. We are here today for sentencing on a case involving a conviction for operating while intoxicated, if I recall. Or no, possession of meth. I'm sorry.
No,
Hold on. I grabbed the wrong one. Somebody gave me two, but that's okay. Phew. No, we're here today. This is the assault with intent. I've got it. And then the domestic violence. All right, thank you. Let's take a quick look here. There's also there's a recommendation that it be placed on HYTA, but it's not an agreement.
Correct.
All right, Killebrew. All right, let me take a quick look, see if we have the court noted any change.
I'm sorry, Your Honor.
Okay, no.
I believe it was a.
Yeah, you're right. I'm sorry. When I said the word recommendations, because unfortunately I looked at Mr. Van Atwell's recommendation. Thank you very much. I'm going to take a quick look, see if I found any corrections. All right, not seeing any. Do we have any victim impact statement today? Oh, wait, no, I'm sorry. Miss Dahl, why don't you go and tell me if you have any corrections or amendments?
I do not know.
Mr. Harrison.
Nor do I.
Back to you, Miss Dahl. Do we have any victim impact statement being made today?
Yes, a letter that I would like to read on the record.
You may.
Court, it is my opinion as Jacob Johnson's father that further jail time will not benefit in teaching Jacob a lesson. I do believe he learned his lesson and at the most probation would be sufficient if he is released today. I believe he knows he messed up and he is willing to start doing the right things in life to be a successful part of society. I want him to know that I love him very much and I'm keeping him in my prayers. I'm hoping that we can rekindle our relationship after he gets his things together.
Thank you. Allocution, Ms. Dahl?
Your Honor, I believe that the recommendation by probation is appropriate. The only thing that I would ask the court to add is that he get a mental health evaluation and follow any and all recommendations of that evaluation. I believe this stemmed from an incident where he may have had some issues with his father in the past. He became homeless and lived in with his father temporarily while he got his life in order. An argument became inflamed and he ended up committing the acts that he committed. I believe that he even self-admitted that he has some mental health issues. So I believe that as part of probation and our recommendation, HYTA, I believe the mental health treatment will be essential to making sure that this doesn't happen again. I believe he needs to work on his issues. He has no criminal history whatsoever, so I believe that with some treatment that he can get back on the straight and narrow, and hopefully we won't see him again. The goal of the justice system is to ensure the safety of the public. His act was egregious, unnecessary, and I believe some mental health treatment would help ensure that the community is safe and that he is no longer doing the things that he is doing. Thank you.
Thank you, Mr. Harrison.
Well, it's odd because I don't disagree with a lot of what the prosecutor, Ms. Dahl, had to say just now. I think Jacob has exerted a lot of effort to overcome some obstacles in his life, such as perhaps some mental health issues, things along the line. He presented himself to the United States Army and, as he put it, a lowly E2 when he was separated from their employment. And I think that's indicative of his situation where there hasn't been, despite him searching for it, there hasn't been a lot of structure. Even right now, we had a way to pull back and see the big picture with some kind of camera, we would see that even right now, he doesn't have a permanent address. His hope is that he will be able to get everything together once he's released from jail. And I have to say, I've seen a change in Jacob in the few months. He's been in jail for 127 days. And the few months that I've known him, I am confident, as he is right now, that he has the wherewithal to make the necessary changes. He's a young man. He has no prior criminal history. This need not represent anything more than an opportunity for him to learn a valuable life lesson. And I think that's exactly what has come of it now. I think he said things to me while we were developing the case that he's actually glad he ended up in jail at some point, because it gave him the opportunity to slow everything down and think about what he needed to do to provide for himself in the future. I think he's a young man that has a lot to offer. Physically, I think he has some perspective from a mental perspective as well, as far as his state of mind and his view of the world. And I think with some minor tweaking and some regular attention to his mental health, he's going to be a force to be reckoned with in the future in a positive way. I would encourage the court as well to follow the guideline here, or the recommendation rather, especially in that it's attractive to him and obviously to me as his advocate that he have the structure in his life that's going to be imposed by being under supervision, that will serve as a reminder to him not to fall back, not to regress, but to keep moving forward. Thank you.
All right, Mr. Johnson, you have the right to make a statement. Is there anything you wish to say before I issue a sentence?
Oh,
All right. Well, Jacob, let's hope you figure this out. Mr. Van Amel, I do know that condition 4.22 does talk about complying with written or verbal orders of the field agent. I specifically highlight that it should encourage some kind of mental health treatment or counseling. And I know it's talked about in here that he's been working with CMH. I also see in the Compass chart, it talks a little bit about his cognitive socialization history and how he might need some treatment. So I definitely think that Ms. Dahl's request or suggestion is spot on. The court sentenced the defendant to 24 months pursuant to the Homeless Youthful Training Act. The court adopts the terms or conditions for that period of deferral that are contained in CFJ 145 pages 2 and 3. I find that those conditions are well suited for rehabilitative purposes. The court sentences the defendant to 127 days with 127 days of credit. The court also assesses a $50 state minimum fee, a $75 crime victims' right fund fee. I'm going to say $150 court cost, $150 attorney fee, a $200 fine, supervision fees of $30 a month or $60 a month if there's any electronic monitoring. I find that sentence is reasonable and proportionate. It's also consistent with the pretrial agreement. Anything else, Ms. Dahl?
No, Your Honor.
Mr. Van Apple?
Yes. Sorry, Your Honor. Based on the written statement provided by the defendant's father, still want condition 4.5 listed in the.
Yeah, so here's. Yep, I saw that, and I mentioned to say to you that. Did he say did he say he wanted that lifted?
No, he wanted to keep it in place until he knows that he is stable.
So that's what I kind of perceived from it. So Mr. Van Apple, if you hear from the father who's the victim and he wishes to, you just submit it in a motion to amend and I'll go ahead and sign it as long as he agrees to it. All right, Mr. Johnson, let's figure this life out and don't come back and see me in orange. Okay. All right. Now, I'm wearing orange today, by the way, but I went to whole college, so I love orange. But anyways, unless you got a big H, never mind. You got it. We'll see you next time. Hopefully, it's not a next time. But There we go. We're adjourned. All right, Miss, I'm going to jump backwards and take people of the state of Michigan versus Adrisi Malai. Thank you. Molly, you told me that, and I was getting ready to apologize. I knew I had it wrong.
Yeah, I can see it right.
Cool.
Put it together.
That's it. So you did, Molly, yep. This is case number 26-14234FH. Appearances, please.
Good morning, Your Honor. Unique Vandenberg on behalf of Mr. Molly, who was present, and Mr. Benton will be seated to my left.
All right, thank you.
Thank you.
Department of Corrections, who has prepared today's pre-sentence investigation report. We're here today for a sentencing, and there's a Killebrew agreement for a sentence under 7411. I don't have any corrections to the report. It was carried to you.
No.
Mr. Hartel, do you?
After reviewing with my client, we do not, Your Honor.
All right, Mr. Hartel, pay attention. Sure.
Yes, Your Honor.
All right, we need to catch up, which should tell you I'm likely to go along here with the agreement for 7411. Got it?
Yes,
You
Your
know
Honor.
what the Killebrew is?
Yes, Your Honor, 7411.
All right. Wink, wink. Shorten it up. Ms. Carey, allocution.
Court follow the recommendation in the agreement.
Thank you. Mr. Hartel.
The same, Your Honor.
Powell, do you wish to say anything? He shook his head no. Thank you very much. I do appreciate that. I see Mr. Powell smiling. All right, thank you very much. The court sentences the defendant as follows. The court places the defendant on a period of probation pursuant to section 7411 under the Public Health Code for 12 months. The court adopts the terms or conditions that are listed on CFJ 145, pages 2 and 3. I find that those are well suited for rehabilitative purposes concerning the facts of this case. The court sentences the defendant to 3 days of jail with 3 days of credit, $68 state minimum fee, $130 crime victim right fund fee, a $300 court cost, a $300 attorney fee. Find that to be fair and reasonable. Do we have to do a DNA fee here?
No, we do not.
No
No,
DNA.
wait. Yes.
Oh, so yes.
$60.
$60.
County Sheriff.
Wexford County Sheriff. Supervision fees are $30 a month or $60 a month if there's any electronic monitoring. Oh, and a fine, the fine of $500. Thank you. Mr. Saladay, we should give you a chance to say something today. Anything?
No, Your Honor.
Great. Ms. Carey, anything else?
Nothing.
And Mr. Hartel?
No, thank you.
Thank you. All right, Mr. Powell, I do not need to put you, talk to you about appellate rights because your sentence is not yet final. All right, if you complete the 7411, then you'll get the benefit of the dismissal. Do not test positive. Okay, not that you have so far, not that you would. Is that your spouse in the back?
What's that?
Yeah, she's shaking her head. Do not let them test positive.
No.
Thank you. Let's be positive here. If you need any help, go to Mr. Saladay first. You need counseling? He'll help you hook up. Catholic Human Services, addiction treatment services up in Traverse City. There are a lot of opportunities available. There's a lot of stuff online that you can access with an app. Please look for it because I want to see it turn out better from this. And I can't wait to, well, I can't wait, I have to, but I'll wait for 12 months and I'll sign that dismissal successfully, okay?
No problem, sir.
All right, good enough. Thank you very much. We are adjourned.
Case in which she's alleged not to have reported to jury.
Of course you were.
So it, you know,
All right, hold on.
kind of comes full circle.
Let's take a look here. Looks like I had an arraignment back on March 23rd.
Yeah.
She requested counsel. Posted a $500 bond. I issued the bench warrant last year on April 21st. Her failure to appear for jury service. Now, Mr. Harrison. Pay attention. Mr. Harrison, the court here is really, because last time Ms. Maria Perry, gosh, should be easy. Perrier with an A on the end.
Yeah.
All right, Perry up. What happened? Just tell me what happened. Why did she make it?
Literally just out of sight, out of mind. I started a new job, have 3 kids by myself. It was just total accident.
Miss Perry, and my reason here is that I generally make people come in. I didn't recognize you, and you were sitting there by yourself, which tells me you weren't married and here to watch somebody else. And so I made you sit here a little bit. Jury selection is a very difficult and important process, and if we cannot pick a jury, we lose. We, meaning the people of Wetcher County, lose one of its trial days, and that means this court sits empty. And like, no, but I can only do about 24 trials in a given year, covering 2 counties. And one of those days, because we don't have enough jurors, then it's important because we've lost the ability to prosecute a case or pursue a civil lawsuit or do a divorce, not a divorce, but a lot of other matters. So I just want to make sure that you pay attention. And plus, if I don't make people come, which I do a lot, then the word gets out. I just don't show up. Now, I don't see here where you would ask to be released, and then I told you, no, you needed to come, and then you failed to come. Now, those work out a little bit differently, but I'm glad that you showed up, and I'm glad that you explained it. That's okay.
Exactly.
All right, well, this is the quickest, most effective case Mr. Harrison has ever handled.
I am particularly cognizant of the fact that actually happened, where we did run out of jurors because there were a number of people who didn't show up.
Yeah.
So the court's concern is well placed.
Yeah. All right. The contempt charge is hereby dismissed, which means your bond can be returned back to you. Today, I like those 80s glasses or 70s, I think. Linda Ronstadt, I think, used to always wear them.
Yeah.
I'm
The
sure.
bigger the better.
There you go. All right. Thank you, ma'am. Have a good day.
Actually,
Excuse my
do
voice.
you know who Linda Ronstadt is?
I don't.
Oh, my goodness.
You look just like.
Oh, my goodness. She helped give the Eagles their start. You've heard of the Eagles, right?
Yeah.
All
They
right,
were,
well,
they were her band.
they were her backup band. All right, we're adjourned very nice.
But she had a better band after that.
Yeah, yeah. She is one of the most, I think she's the longest, no, most. She joins me.
Perhaps it ended.
This courtroom session delivers a powerful reminder of how the justice system balances accountability with rehabilitation. In Jacob Johnson's case, the judge ultimately leaned toward a second chance, sentencing him under the Home's Youthful Trainee Act, which means his record could stay clean if he successfully completes probation. That's huge. It shows the court recognized not just the severity of the offense, but also his lack of criminal history, his personal struggles, and the role mental health may have played. What stands out here is the alignment between both sides, prosecution and defense, agreeing that treatment and structure could prevent future harm. Add to that the emotional weight of a father advocating for his son instead of against him, and you've got a rare moment where the system, the family, and the law all point toward rehabilitation. Then, in contrast, we see a second defendant receiving a lighter sentence under a different statute, and finally, a completely separate situation where a missed jury duty almost led to consequences, but was ultimately dismissed. 3 different outcomes, all in one courtroom session, each showing how context, attitude, and circumstances can completely change the result. So what do you think? Did the judge make the right call focusing on rehabilitation over punishment? Or should the system be stricter in cases like this? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.